Good morning. My name is Aaron Street. I'm the president of the Houston Lawyers Chapter, and it's my privilege to welcome you to the 2017 Texas Chapters Conference. It's meaningful to host this event in Houston just weeks after Hurricane Harvey visited disaster on our city. Moving forward with events like this illustrates Houston's resilience and reminds us that while we have a lot of work ahead of us, we are all on the road to full rebuilding and recovery. We are honored this morning to present a distinguished slate of panels, capped off with a keynote address by Senator John Cornyn. The panels focus on a debate that is as old as the Republic itself, the nature of the executive branch and the limits on its authority. A principled discussion of federalism and separation of powers as they relate to the executive branch is as salient today as ever. It's been often observed that every 4 or 8 years, the party that's just been ousted from power magically rediscovers the virtues of the separation of powers and federalism. But as Senator Ben Sasse reminded us at last year's Barbara Olson lecture, it is glorious when we believe in limited government and restraint, when we are the ones in power. Today's aim is to have a principled, vigorous discussion of executive branch authority, as well as the limitations and checks on that authority that should apply regardless of who is in power. To that end, I call upon our first panel and James Lloyd, a board member of the Houston Lawyers Chapter, to introduce our moderator.
Good morning. I'm pleased to kick off our first panel, which will explore executive power over immigration. Our moderator is Judge Jerry Smith of the U.S. Court of Appeals for the Fifth Circuit. Judge Smith began his career clerking for Judge Hal Woodward of the Northern District of Texas and became a partner with Fulbright and Jaworski. Judge Smith's leadership in public service extends across government, having served senior roles for the City of Houston before his appointment to the federal bench by President Ronald Reagan. As most in this room would know, Judge Smith is a leading voice in conservative jurisprudence and has a long history with the Federalist Society. We are also delighted that FedSoc is a family affair for the Smiths, as Mary Jane, his wife, and his son Clark have joined us today as well. Judge Smith, thank you for joining us today.
Thank you, James. We're going to spend this first segment on a topic that is completely non-controversial, which is executive power over immigration. We'll examine questions such as what is the constitutional and statutory scope of the executive branch's power in the area of immigration? How does the executive's enforcement or lack of enforcement of immigration law impact states and local cities? This panel is a discussion from the federal and state perspectives on the current status of the executive's implementation of immigration law and the scope of the executive branch's power and discretion in the area of immigration. The topics include prosecutorial discretion in the enforcement of immigration law, the executive's statutory and constitutional power to exclude aliens from entry, sanctuary cities and the potential consequences of refusing to cooperate with federal immigration authorities, and whether statements made on the campaign trail can be used in determining the legality of an executive order. We have a spectacular panel for you here today, and I think you'll really enjoy their insights, and it's a varied panel that will give you all perspectives on this issue. We'll be listening to our three panelists, each of them going in the order that I'll present them, and then they'll have some response to each other, and we want to save time for questions, so please think of some, not speeches, but questions at the end. We look forward to hearing from you as to what you'd like these panelists to add to what they have already said. We begin with Allison Ho. Allison is a co-chair of the appellate practice at Morgan Lewis in Dallas. She's held senior positions in both the White House and the Department of Justice. Allison served as a special assistant to President George W. Bush and counselor to Attorney General John Ashcroft, overseeing the Justice Department's Homeland Security and immigration enforcement efforts. She previously clerked for Justice Sandra Day O'Connor, and of course, most importantly, on the Fifth Circuit for Judge Jack Weiner. We're also pleased to welcome Andre Segura. He's the legal director of the American Civil Liberties Union of Texas. Andre has focused his work on the civil rights of immigrant communities, including challenges to President Trump's executive orders on immigration. His practice centers on immigration enforcement by federal, state, and local law enforcement agencies. Andre is a native of Houston, has just returned, in fact, to Houston, and was previously a fellow with the ACLU's Racial Justice Program. He was a litigation fellow with the ACLU's Northern California affiliate, and he was a law clerk to Judge Napoleon Jones of the U.S. District Court for the Southern District of California. And our third panelist is Brantley Starr, who's the Deputy First Assistant General of Texas. He previously served as Assistant Solicitor General under Ted Cruz and under Allison's husband, Jim Ho. He practiced commercial and appellate litigation at King & Spalding and was a staff attorney to Texas Supreme Court Justice Eva Guzman. Brantley began his legal career advising then Deputy Attorney General for Legal Counsel, Don Willett. He later served as briefing attorney for Justice Willett upon his appointment to the Texas Supreme Court. Brantley returned to the Office of the Attorney General in 2015 as Deputy Attorney General for Legal Counsel. So to begin the discussion, Allison Ho is going to lay out for us some history.
Thank you, Judge Smith, and thank you for that kind introduction. Although, Judge, you did leave out an important aspect of my biography, and that's that I'm married, as the judge said, to Jim Ho, who is a Judge Smith law clerk. So, just for stating that for the record. It's as a fellow, he's native Houstonian. It's a special pleasure for us to be here with you in Houston this morning at this time. Between 2011 and 2013, when pressed by immigration advocates to take executive action that would prevent the deportation of millions here illegally, President Obama repeatedly said that taking such action would be outside his executive authority as president. This statement from 2013 is typical. Quote, "The problem is that, I'm the president of the United States. I'm not the emperor of the United States. My job is to execute laws that are passed. And Congress right now has not changed what I consider to be a broken immigration system. And what that means is that we have certain obligations to enforce the laws that are in place, even if we think that in many cases the results may be tragic." Nonetheless, in November of 2014, after failing to achieve the passage of legislation that would have enacted his administration's preferred policies, President Obama took the executive action that he himself had repeatedly declared beyond his authority, saying, quote, to those members of Congress who question my authority to make our immigration system work better, or question the wisdom of me acting where Congress has failed, I have one answer. Pass a bill, President Obama said. I want to work with both parties to pass a more permanent legislative solution. And the day that I sign that bill into law, the actions I take will no longer be necessary. Even Saturday Night Live recognized the issue of executive overreach here, spoofing it in a Schoolhouse Rock skit aired within days of the announcement of the executive action. The skit featured cast members dressed as an immigration bill on one side and the executive order on the other, with a naive student asking the order, wait a second, don't you have to go through Congress at some point? And the chain-smoking order responding, aw, that's adorable. You still think that's how government works? Well, yes, it is. Article 1, Section 8 of the Constitution gives Congress authority to establish a uniform rule of naturalization. In INS versus Shada, the Supreme Court made clear that the plenary authority of Congress over aliens under Article 1, Section 8, Clause 4 is not open to question. That principle was reaffirmed more recently in Arizona versus United States, when the court held that Congress could trump state laws dealing with illegal aliens through the preemption doctrine, but competing executive branch enforcement priorities could not. The president's constitutional duty to enforce the laws, referenced by President Obama in the 2011 quote with which I began, derives from Article 2, Section 3, which states that the president shall take care that the laws be faithfully executed. This is imperative language. It instructs that the president shall take care. His duty is to execute the laws, not some of the laws, but all of the laws. And he has to faithfully execute those laws. President Obama justified his own executive action on immigration by referencing prosecutorial discretion, citing a memorandum from the Department of Justice's Office of Legal Counsel. And I know my fellow panelists will be talking a little bit more about this in detail, so I don't want to spend too much time on that at this point. But I think it's interesting to point out that the OLC memorandum upon which President Obama relied provides that, quote, an agency's enforcement decisions should be consonant with, rather than contrary to, the congressional policy underlying the statutes the agency is charged with administering, and that immigration officials cannot abdicate their statutory responsibilities under the guise of exercising enforcement discretion. I think former Immigration and Naturalization Service Commissioner Doris Meisner, who served under President Bill Clinton, once stated, she put it this way, she said, prosecutorial discretion should not become, quote, an invitation to violate or ignore the law. Instead, prosecutorial discretion with respect to an executive's enforcement duties is based on equitable considerations in an individual case or a small set of cases. It's not a license for the executive to seize congressional prerogatives. Yet, in fairness, for decades, Congress has delegated a great deal of its own immigration authority to the executive branch in sweeping grants of power. I think arguably more than in any area of the law. To give you a few examples, Congress has delegated the power to the executive branch to determine whether foreigners should be granted temporary protected status, whether a person is allowed to work in the United States, whether to grant a person permission to be in the United States when the person doesn't qualify for a visa, and whether a person's deportation should be deferred. As a result, the executive branch today enjoys expansive power over immigration as a result of the delegation of congressional power over immigration. Especially relevant to today's discussion is a 1952 law, 8 U.S.C. section 1182F, that gives the president what one scholar has called capacious authority to deny entry to any alien or class of aliens whom the president deems detrimental to U.S. interests. Again, I know my fellow panelists will be discussing this in greater detail. I think it's enough for now, perhaps just to read the statute in full. It says, whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Capacious indeed. Today's discussion of executive authority and immigration raises issues not only of separation of powers, but also of federalism. As an empirical matter, the costs and burdens of illegal immigration do not fall evenly on federal, state, and local governments. So if the executive fails to take care that the laws be faithfully executed, or if Congress fails to sufficiently fund enforcement efforts, then the brunt of it is borne by states and locals. That reality has led to a series of clashes between states and the executive branch, including the Arizona Supreme Court case I referenced earlier, over efforts by states unsatisfied with the executive's enforcement efforts on one hand, and also efforts by the executive unsatisfied with cities' refusal to cooperate with federal enforcement efforts on the other. So immigration is not only an exceedingly complex policy matter, but it also implicates two foundational principles of our republic: separation of powers and federalism. And I look forward to my federal panelist discussion of how these principles are playing out in current cases and controversies.
Okay, Andre Segura.
Oh, great. I thought Brantley was up first.
You want to go first?
Well, thank.
I'm fine going next.
Oh, it's whichever you prefer.
Paper, rock, scissors?
Brantley, why don't you go ahead?
That's why you're the judge. Appreciate that. Okay, so Brantley Starr, Attorney General's office. I'm here to share some state perspective on these issues that Allison very aptly laid out. And by state perspective, I mean Texas perspective, because I'm not here to share what the views of the New York Attorney General's office might be. I do have to say that instead of articulating legal principles, what I'd like to do is walk through about 3 cases with you that lay out these principles, and we can see them in action and give you the flavor of the view that the state of Texas has towards each of these cases and the principles that they stand for. The first is the travel ban case, and Allison brought this up earlier. We have the statute in the INA that basically allows the president to pause entry into the country from a class of aliens if he finds that it's detrimental to the interests of the U.S. to allow them to be here. We know that the president had made campaign trail statements that he believed that the vetting process was insufficient. And we know that that's one of the few specific issues that he and Jim Comey agreed on. And then he became president, and shortly thereafter signed an executive order that paused travel into the country, or banned travel, depending on which moniker you would use. And the second iteration of that executive order banned travel from 6 different countries for 90 days. And that list of 6 different countries came not from the Trump administration, but came from the Obama administration and Congress. Those were the national security concern countries of interest. And in addition to that travel ban, there was also a refugee pause as well for 120 days to enable the executive to examine its vetting procedures for refugees to ensure that refugees coming here weren't going to be detrimental to the interests of the U.S. And so those were the 2 main components of the executive order that composed the travel ban. The president obviously cited his justification as that provision in the INA, saying it's up to the president if he finds it's detrimental to the U.S. to pause travel. Other presidents before him invoked that authority and used it as well. He was sued, and we all know that the Ninth Circuit and the Fourth Circuit issued complete injunctions against the executive order. And so I'd like to walk through just briefly what the basis for their injunctions were, and then go through what the Supreme Court acted on and where we can see that case going here in October. So what the Fourth Circuit held was that there was essentially a constitutional limit on this executive order, that the president was acting with animus, that he was more concerned about animus against Muslims than he was about protecting national security. And that because of that, his actions violated the Due Process Clause and the Equal Protection Clause. But it's interesting, in these cases involving animus, we have this outer principle from the Supreme Court's case in McCreary that notes that courts aren't likely to psychoanalyze our drafters' hearts. And so as a result, when you have a facially neutral law or executive order like we had here, then it requires the clearest proof that there was pretext, that when the drafter was doing what they did, that the words they were choosing were simply pretext for the animus that was in their heart. Again, here, this was a facially neutral order. right? Because we didn't see discrimination that said Muslims can't come into the country. That was not the list that he used. He used a list from a former administration and from Congress. And so as a result of that facially neutral executive order, there needs to be the clearest proof of pretext. And we simply didn't think from the record that they had met that burden. The key rationale from the Ninth Circuit was in a different place. It wasn't based on animus, but instead, it was a belief that the president hadn't actually met his burden under the INA of a sufficient, discrete showing of how the U.S. would have its interests acted upon were these individuals allowed to travel to the United States. So it was a statutory argument. The problem is, if we go back to our Common Law 1 textbooks, we all know Youngstown, Sheet and Tube. And the principle from Youngstown was if Congress has authority in an area and they cede it all to the executive, as Allison mentioned, they did with this particular provision of the INA, then the president is acting with all the power of the political branches of government. And it's an exceedingly difficult thing to invalidate that type of presidential action. There was another basis that I want to bring up just briefly that the Ninth Circuit and the Fourth Circuit relied on, and it's procedural due process. There's a question that all of us have in our minds, which is how far does the Constitution extend? Does it extend overseas? Does it extend to aliens seeking entry into the country? And essentially the Ninth and Fourth Circuits were adhering to at least some form of this principle that it would extend to aliens seeking entry into the country who had not yet been here. We filed an amicus brief in this case in the U.S. Supreme Court. Originally, when Scott drafted it, we were on our own, and then there were 16 states that eventually saw the light and joined it. And that amicus brief argued that under Supreme Court jurisprudence, you simply can't extend the Constitution that far to someone who is an alien who has not yet been admitted into the country. The Constitution would be stretched to the breaking point and wouldn't know a limit if it was extended that far. The fallback position that we articulated was, at a minimum, the non-residents must have sufficient contacts with the United States for any sort of constitutional notion to kick in. And that's actually where the Supreme Court acted. We saw in June, right before they left town for their July recess, they issued a stay of the Ninth Circuit and the Fourth Circuit injunctions. And the stay doesn't fully explain why the court was doing what it was doing. But what the court did was, it said that there has to be a bona fide connection between the non-resident seeking entry and the United States, either an individual or an entity in the United States, in order for the travel ban to not apply. In other words, only those individuals with a bona fide connection could come here, otherwise the travel ban applies. Now, when we talk about a connection to an individual, they cited examples as if it were a wife or a mother-in-law. A mother-in-law, really, as a matter of law, a mother-in-law is a bona fide connection. I think that's a prime example of when you would use a case-by-case analysis. But for entities, a connection to an entity that it mentioned is like a student seeking admission to a university. So those are the type of connections that the court is talking about. Now, there was a concurrence and dissent from Justices Thomas, Alito, Gorsuch, and they raised 2 points that I think are worth reiterating here. And the first point is that if you take one of these cases where an individual with a bona fide connection had sued, and you have a preliminary injunction that extrapolates that to everyone who's similarly situated, then you just instantly transformed what's not a class action into a class action, number one. And then number two, that if you have a line like a bona fide relationship, how do you patrol that? And it's going to be patrolled by the 2 district courts who created injunctions that all 9 justices thought were incredibly overbroad. And that second point is proven true already because Justice Kennedy already had to issue another stay in the case involving refugees covered by a formal assurance. Not sure what that means. I'm sure further litigation will spawn over that. But the court's going to hear oral argument in October, and hopefully we'll get an understanding for why the court was drawing the line that it did in the stay posture, and it could draw a different line if it wanted to. But I would say that the travel ban case really does stand for the proposition that we heard from Allison, that if Congress grants its authority in the area to the president, then this is Youngstown Zone 1, and the president is acting at his apex. The second set of cases, sanctuary cities. Now, you are probably in this room more familiar with the Texas sanctuary cities case than the others that are around the nation. But because Andre and I are litigating right now on that, and it's in the Fifth Circuit, we're going to pause discussion on that. That would be rather awkward. We would each be trying to convince someone else at the table that we're right. And instead, we will focus on the cases that you've probably seen from San Francisco, from Chicago, on the executive order on sanctuary cities, and that gets more into the heart of presidential power. So the executive order, as a background, there's a section 1373 in federal law that basically says that state and local governments aren't supposed to inhibit the flow of communication to ICE regarding immigration. And so if I'm the Harris County Sheriff, I'm not supposed to tell my deputies, don't call ICE with immigration status information. If you stop someone, you find out they're here illegally, don't call ICE. Section 1373 is designed to prohibit that. So the president issued an executive order saying that based on section 1373, if there's a local entity that's not complying, then the federal government is supposed to withhold grant funding to that local sanctuary jurisdiction, quote, except as mandated by law. As a result, San Francisco was one of the first to sue, and there were 3 different local governments in that suit, all of which had these sanctuary policies that we know would violate 1373 because they inhibit that flow of communication. But in this case, there's a procedural and a substantive aspect that I want to unpack just a little bit, because the procedural aspect flavors and clouds the whole case. Procedurally, the Department of Justice came in and said that it wasn't interpreting the executive order to apply to all federal grants, but simply interpreting that executive order to apply to 3 total federal grants, all of which already had compliance with Section 1373 baked into it, into the grant contract between the feds and the locals. The court did not adopt that narrowing construction. It did not take the enforcer of the law at its word. And so as a result, it went through a cascading series of constitutional analysis that I want to go through because I think it has really significant import for how the case should go forward. But it's difficult to understand how this case will go through, knowing that this lawsuit was in a pre-enforcement facial posture. And based on that posture, we know that if there's one circumstance in which this executive order could apply constitutionally, then it should survive that challenge. And so that ruling that the enforcer of the law, their interpretation of how they will enforce the law doesn't hold, to me is irreconcilable with the posture that the case was in. If you get past DOJ's narrowing argument, there are some really weighty constitutional issues here that I think San Francisco could be right on depending on what the record reflects. The first one is the principle that it's up to Congress, not the executive branch, to attach strings on federal dollars going to the states. That's a 10th Amendment and spending clause principle that was perhaps made most clear in an Alito opinion from 2006, Arlington Central School Board versus Murphy, that we might have sued the federal government on 5 or 6 times in the last couple of years. It's a principle that's really significant because essentially we know that if there's any federal appropriations bill other than Obamacare, it has to originate in the House. And as a result of that, these appropriations are essentially contracts between Congress and the state or local government that is receiving this funding. And so it's not up to the executive to intervene and say, well, Congress imposed 5 restrictions, but we've got about 20 more that we're going to impose on state and local governments. It's a contract between Congress and the states or locals. And so we need to understand in this case if the record really does reflect, was this truly the Obama administration adding these strings in 2016, or was this inherently something that Congress itself did? But there could be serious concern for the executive if the Obama administration itself added these restrictions. A second principle here at play is that these restrictions actually have to be unambiguous. It's related to the first notion that Congress has to make it up, but if Congress creates this restriction, just as Alito said in Arlington Central, it's got to be clear and unambiguous so that the state knows what they're accepting or the local knows what they're accepting. So no, there's no such thing as agency deference when it comes to this 10th Amendment principle. It doesn't exist. A third requirement is that there's got to be a nexus between the restriction and the purpose of the grant funding. And so if the feds are doling out highway money, then they can condition that on your drinking age being 21, but they can't condition it on you having some sort of non-discrimination policy for how you hire all of your state employees. That's not relevant enough. And then we know from NFIB versus Sebelius that it can't be coercive. That restriction can't be a gun to the state or local government's head. So I do think that once we get past this posture and understand truly what is being argued in the case, there are meaningful restrictions on the executive's power from the sanctuary city's executive order cases. And then the last cases I want to talk about are DAPA and DACA. And this is what Allison alluded to earlier with President Obama's comments on, I'm not the emperor, I can't just change the law. As background, we know in 2012 that the president did implement the DACA memo, and that was essentially granting lawful presence status to applicants, child applicants who met all the criteria that the administration had set out. In 2014, that got expanded DACA, and we saw DAPA as well. And that DAPA is where Texas led a 26-state coalition who sued before DAPA was ever implemented. There was a preliminary injunction, and that lawsuit that brought about the preliminary injunction had two counts to it. One was an Administrative Procedure Act count, and everyone's eyes just glazed over instantly when I said that. I can see it. And so that was on notice and comment, right? And so I won't bore you with that, but the essence was that the DAPA memo was a rule, and rules have to go through notice and comment rulemaking to be valid under the APA. But the second count was perhaps the more interesting one, even though the courts never really addressed it. The injunction was on the APA claim. It was affirmed by the Fifth Circuit on that APA claim. And then an evenly divided U.S. Supreme Court affirmed the judgment below. And so we only saw discussion of the APA claim. We didn't see discussion of the Take Care Clause claim. And that was the point that Allison mentioned earlier. We've got the constitutional requirement that the president take care to faithfully execute the laws of the United States. DAPA simply was an inversion of that. And as I talked to a number of people, and even a number of Texas appellate justices, none of which are in this room, it's only the justices who are not in this room, I often heard the view of the case as being only about prosecutorial discretion. And that the view was it's a very close call because can you have prosecutorial discretion category by category instead of case by case? And that is a fascinating question. But to me, the more interesting aspect of this Take Care Clause debate lies not in prosecutorial discretion, but the point that Allison mentioned earlier on can you invert the law? Can you rewrite the law? And when we look at DAPA, we know that's exactly what was going on. In the INA, which is pursuant to Congress's plenary authority, they were saying that there's a class of individuals who are not lawfully present and are therefore removable. And then the president came in and said, well, here's a broad subset of that category of individuals who Congress says are not lawfully present, but I am now going to deem lawfully present, and gave them rights and privileges. That's simply an inversion of the law. And we know that that cannot stand under any view of the Take Care Clause or Schoolhouse Rock, how a bill becomes a law, which is how I teach my children separation of powers. So I would submit to you that what we can learn from these three cases is that there are good indications of what power the president has and what power the president doesn't. And so under travel ban, we know that because Congress has granted their authority to the president, he has the ability to pause entry if he deems it detrimental to the interest of the U.S. not to do so. We know from the sanctuary city's executive order that the president himself can't attach strings Congress chose not to attach on federal funds that flow to the states, and then from the DAPA and DACA situations that we know that the president simply can't rewrite the INA.
All right, Andre, if there is anything that you might disagree with in what you've heard, you can have as much time as you need to review.
I was just telling Allison that it seems like I was writing a rebuttal to Brantley while he was speaking. But thank you all for inviting me here to speak. This is obviously not the ACLU's usual crowd, but we are in these debates, obviously with the state of Texas, the federal government, and I do think that there are points that we can agree on, and there are points that we will likely always disagree on. So I just want to start by without any judgment. I think this administration, I would not say personally, came in with a lot of very clear, concrete goals. But I think one area in which there are concrete goals in this administration is in immigration enforcement. President Trump, from the beginning of his administration and his campaign statements and his nomination of Attorney General Sessions, made very clear that he wanted to further restrict immigration and increase immigration enforcement efforts. So shortly after the inauguration, he issued several executive orders, two of which Brantley was speaking about. The first one that he issued was on interior enforcement. So this is where the Trump administration set out to increase enforcement and the number of deportations per year. And he wanted to do that in a variety of different ways. One way that was very specific was to have 10,000 more interior immigration enforcement agents, ICE agents. And in a similar border security executive order, he called for 5,000 more border CBP officials. So very clear from the beginning what the president wanted to do on immigration. And then shortly thereafter, he issued the infamous or famous, however you want to call it, Muslim ban for the first time, which was then subsequently amended a few months after that, following litigation from the ACLU and from others. So I think there are, just to talk about some of the things that we are in agreement, and I think it's all about the degree. And, I think naturally the degree changes based on administration often. So I think, we agree that Congress sets immigration law policy. The executive generally is charged with enforcing that. Those are general principles that we agree on. The states can cooperate in immigration enforcement to certain extents. And I think those are the broad outlines. And I think within that, there are millions of pages of legal documents debating what any of that means. And I think that's where we are on all of these cases, including the case that Brantley and I are currently litigating here. So I want to start the conversation here in Texas, naturally, with talking about California, which I'm sure we'll go over. Great, but this is the case that Brantley was talking about. It's the, I refer to it more of the Santa Clara case, but it's the San Francisco Santa Clara case in which they sued the federal government to block enforcement of the interior enforcement executive order. And so this interior executive order sought to essentially punish what it called sanctuary cities or sanctuary jurisdictions within the executive order. There is no definition either in that executive order, in any law, or in any text about what exactly is a sanctuary jurisdiction. Historically, that takes on a lot of different forms. Some jurisdictions decide, here are the places in which we're going to cooperate with immigration enforcement. Some jurisdictions decide we're not going to do any. But fairly universally, all jurisdictions comply with the one thing that they absolutely cannot do, and that's to prohibit, what Brantley said, information sharing of specifically immigration status under 8 U.S.C. 1373. So that is the specific thing that Congress had said, that no state or local jurisdiction can prevent their officials from communicating with the federal government just about immigration status. And so almost universally, I'm sure there are exceptions, but most jurisdictions do comply with that. Now, this executive order, Santa Clara and San Francisco, and we also we moved to intervene in that case as well, but we argued that that executive order was extremely overly broad, was vague, and as Brantley said, intruded on a lot of separation of powers, 10th Amendment coercion issues, and spending clause issues. Now, I think there are a few issues at play in that case, and I think we have to remember this was a challenge to the executive order prior to it actually being enforced. And I think that's what Brantley was hitting on, sort of like where we are in this case and how a judge is supposed to look at it. And so one of the main issues that the judge has to look at is the potential for harm to the plaintiff if the challenged action is allowed to take effect. So Santa Clara and San Francisco both receive, Santa Clara receives, I think, $1.7 billion from the federal government in a variety of different funding streams and grants. And they said under this executive order, which does not specify which grants or which funds are at issue, that they risk for the next year all of that funding. And so they need to know exactly what it means. And so what they're looking for is they're rushing into court to get a preliminary injunction so that that can be blocked while it's determined exactly what that means. So I don't think that it's as simple as taking the executive at its word, taking the agencies that are meant to prosecute at its word, because there are significant, there's money on the table. And everyone wants to know what's at issue. So yes, the federal government came in and said, the only thing that's at issue here in this interior executive order are grants tied to 1373. So there are a few grants that are issued by the federal government to state and local law enforcement agencies primarily that have to comply. You have to have a statement that say you comply with information sharing on immigration status to the federal government. And that is, not controversial. And some jurisdictions, including Santa Clara, said, we've made some limitations on that out of our own public safety and public policy. I think they do not share information when it's victims of crimes, for victims of crimes. And, they said, we've made some determination on a public level that we're not going to share all information. But nevertheless, the government said this is where it's limited. That is not written anywhere into the executive order. It says federal funds generally, and it says for those that, I can't remember the exact language of the executive order, but it's something like seeks to limit the enforcement of federal immigration law. So it is very, very broad. And the counties argued that they themselves have their own sort of separation of powers reason and public policy, local public policy reason for not engaging in immigration enforcement, that they reflect local determinations of the best way to promote public safety. And so a judge in San Francisco issued an injunction against the executive order on a variety of grounds, including separation of powers, including that if Congress, in setting up these grants, in setting up 1373, has not given the president discretion on how to execute, how to take care that the laws are faithfully executed, that the president can't then have the discretion to change the conditions of the funding midstream. That's just, that the court found would not be faithfully executing congressional law. And as Brantley was talking about the spending clause test, the court found that this would be coercive because of the amount of money at issue. It would basically require the state or local jurisdictions to take on a federal agency program, regulatory system, I believe it would have said. And the standard is that it cannot be effectively a gun to the head of the local jurisdiction. And also that this would violate the 10th Amendment as a coercive measure, effectively compelling the states to enact a federal program. So the judges put a stop to the executive order for now. I believe it was just appealed a few weeks ago. So I'm sure there will be much more on that topic. The second issue is obviously one on everyone's radar, is the Muslim ban issue that's heading to the Supreme Court to be argued on October 10th. Our legal director, David Cole, will be presenting arguments for our plaintiffs, which come out of the Fourth Circuit decision, and Neil Katyal will be presenting arguments for the state of Hawaii, which worked its way through the Ninth Circuit on October 10th. So it'll be very interesting if, in fact, it actually does go forward. There, as you may have seen the news yesterday, the administration is planning to release a new ban or stop or whatever we'll see what we end up calling it, and it could obviate the need for argument on October 10th, and obviously that will be up to the Supreme Court as to whether to actually continue to hear the argument and to resolve any issues that may still be at play. But I'm sure we'll find out soon, since it's only a few weeks away. So, I think there's obviously a lot of controversy around the Muslim ban. I don't think that there's much disagreement with how the first ban was rolled out and the haste in which it was rolled out. It caused, as you all saw on the news, airports across the country and across the world, chaos. People didn't know what the rules were. DHS agents stationed at airports didn't know how to actually implement the ban that was issued just a day before. And I myself was at JFK Airport when I lived in New York, trying to figure out what was going on at the same time that my colleagues were in court in the Eastern District of New York, asking for the executive order to be blocked while they can actually figure out what's going on. And in fact, on that Saturday night, received a call from my colleague that in fact the judge had issued a stay of the order. And then at that point, it was to figure out how to actually implement that stay of the order on a Saturday night when most people aren't in their offices and it's hard to reach people. So it was chaotic throughout the country. And, I think, like I said, President Trump was very clear throughout his campaign and has been clear on issues of immigration. And he said, from the beginning, he made very clear statements about his intent once taking office, and has not since ever taken back those statements, clarified those statements, narrowed those statements, and has in fact, on his very active Twitter account, doubled down on many of the statements, probably to the frustration of his attorneys, but obviously I wouldn't know that. But as an attorney, if my client were on Twitter talking about cases that I was litigating on his or her behalf, I don't think that any of us would be happy about that. So I think we could probably also agree that clients shouldn't tweet about their thoughts about cases and their reasons for doing certain things that you're currently litigating. But he made very clear statements about a total and clear shutdown of Muslim immigration. He made statements about Islam and Islam hating us. And this is what the court, particularly in the Fourth Circuit, relied on in determining that this was a violation of the Establishment Clause, and that you can look beyond simply the four corners of the page. The court found that you can take in these statements in certain circumstances, and I think we probably disagree on what circumstances or whether you can do that at all. But just to clarify, the first ban did have specifically some statements that were not facially neutral. There was an exception for minority Christian religions within the first ban, which courts addressing that first ban throughout the country hung their hat on and saying, this demonstrates that the law is not facially neutral, and there's no bona fide interest. And so I don't think that I think just simply saying psychoanalyzing might be a bit of an overstatement. There are clear statements that the president has made about the ban, about how it was rolled out, and actually what he intended to roll out. So I don't think that we're imagining what the president might have been thinking, for better or for worse, depending on which side you're on. He makes fairly clear how he's thinking through a variety of different means. So, I think there's some conflict between a view of the president's authority when we're talking about the Muslim ban, and the view of the president's authority when you're talking about a case like DAPA, or maybe we'll be talking about DACA soon, which will be litigated. For guaranteed, there will be a lot of cases about the rescission of the DACA program. And I think, on the one end, folks say, well, in the context of entry, the president has carte blanche. The president can do whatever he wants on the entry of certain immigrants. And then on the prosecutorial discretion side, you're saying, no, everything has to be individual, case by case. And I think there is some conflict between those two positions. In the Muslim ban case, the federal government is effectively relying entirely on 1182F. where the president is given the authority to make individual determinations about whether the entry of an individual would be detrimental to the national security interests of the United States. So we argue that that needs to be made on an individual basis with actual information about that. Here, the ban affects 180 million people from 6 countries without any individualized determination. So the grandmother from one of those countries has not been individually determined by the executive or by the attorney general to present that sort of risk. And so I think what that view of 1182, in our view, then overrides a lot of congressional programs and congressional established procedures on how to grant visas and how to grant entry of individuals. And so the president is basically taking that and could do whatever he wants to do in that area. And we argued that that is far beyond the reach of what a president should be allowed to do. There is another provision that is at play that was passed, in fact, after 1182F, which is that there can be no discrimination on the basis of nationality on the entry to the country in the issuance of visas. And so that's another issue that is at play and that courts have relied on in the Muslim ban. And so lastly, and likely the least controversial of all, but DAPA for the state of Texas. I mean, obviously, I would never suggest that that the DAPA question and granting discretion to a large number of people would not have been a controversial move. I can understand and see the arguments on both sides, but I don't think that this is as extreme as people make it out to be. So the federal government, just to be clear, has never been able to remove more than about 4% of the undocumented population in the country per year. And this is just a matter of practicality. There is no way to remove the 11 million or so individuals in any speedy manner. These people, are everywhere, and that would be an impracticality. So I think we need to understand that there's no way that the executive, in trying to enforce the laws that Congress has established, can simply do it all at once. And so our argument, and the Obama administration's argument, was that the federal government can prioritize removal of certain individuals. And in doing so, has the authority to pass programs such as DACA, or to pass guidance such as DACA or DAPA, in order to establish those priorities. And one of the principal cases, which runs through basically all of these cases, is Arizona v. United States. And there, the majority said a principal feature of the removal system is the broad discretion authorized by immigration officials in the removal process. And so one thing that we wanted to discuss here is what does the take care clause mean? What does it mean to take care that the laws are actually faithfully executed? And it's about a constitutional obligation. It's about the president fulfilling his constitutional obligation to carry out in the immigration field the wishes of Congress. And to be clear, Obama carried out a lot of that during his 8 years. And we sued the Obama administration a lot about the way that he actually enforced immigration law. So I think there's some, sometimes, where was the ACLU during the Obama administration? We were suing the Obama administration for their own immigration enforcement efforts as well. And Obama, every year was arrested and removed hundreds of thousands of people. So I think to say that he was not taking care, that he was not fulfilling his constitutional obligations, I think is an overstatement. And there has been a history, and I'm sure Allison could speak to it, but there has been a history of presidential administration since the 1960s, and in particular over the past 40 years, of using deferred action for individuals and for groups of people. And so just to be clear, because what does deferred action mean? What does it actually stand for, but it's basically just you're placing that person is removable for a variety of reasons. They don't have lawful status, they overstayed their visa, they entered unlawfully at some point in time in the past, that person is removable. But deferred action is basically deferring the action. You're not saying that that person has lawful status, which can include a variety of different things, including lawful permanent residency, which literally means you're allowed to stay forever, permanently. And it can mean a bunch of different things, but what it doesn't mean is that you are always removable. And someone who is under DACA or who would have been under DAPA is at all times, even while they're granted that classification, they are removable. And that's at the discretion of the executive. And President Reagan used deferred action for not just individuals, but for classes of individuals. That was later on carried on by George H.W. Bush, and then later on by George W. Bush and presidents since. And so, I think obviously opinions can change based on who is in power. That is natural in our democracy for us to not be content with how certain administrations or certain sides are using this. But I think we do need to recognize that Obama was not the first one to make up the idea that he was going to grant deferred action for some subset of individuals. This was not his, brilliant idea that he just came up with and ran off with. This is something that other presidents have done. So that's more or less what I have to say on those three cases. On DACA, what I think we're going to see coming up is challenges to the rescission of DACA. And we could probably have a whole conversation about the legal issues at play in that rescission. But there certainly will be an APA claim on the rescission, and I think that there will likely be equal protection claim based on discriminatory motive, similar to in the Muslim ban case. So that's all getting started. I'm sure we'll all be aware of that, and we'll all be watching closely what happens on the Muslim ban litigation coming up in a few weeks in the Supreme Court. So thank you all.
Okay, thank you. Those were excellent opening remarks by each of the panelists, and I'd like to invite any of the three of you to make any kind of response or rebuttal, or if there's anything else that you thought of that you'd like to add. And then after that, we'll be glad to open the floor to some questions. So, Allison, anything that you want to follow up with?
Just a couple of points. I'd like to begin, since there are cameras here, to give Brantley the opportunity to clarify his remark about mother-in-laws and case by case. That, of course, your mother-in-law would sail by, right?
We have a bona fide relationship, but fortunately, she's also not tech savvy, so she will never see a recording of the speech.
Just wanted to give you that opportunity
I appreciate that,
to
Allison.
clarify those comments. And I take Andre's point about President Obama not being the first to act by executive action or executive order. That's certainly true, but I do think it's telling. I mean, I think on the heels of, and I actually wrote it down, Brantley, when you said, to make sure I get your words right, San Francisco could be right. I think that's what you said. I think President Obama was right when he repeatedly said, look, I get your frustration with Congress not acting. But I'm not emperor, I'm not king, I'm president. My obligation is to take care that the laws be faithfully. Of course, I can't rewrite what Congress has done. And I think in announcing the executive action, when President Obama said, well, if you don't like what I've done, pass a bill. I think that action itself was telling with respect to the nature of the action being taken. And I think on the travel ban case, in light of the capaciousness of the statute, which on its face refers to classes of immigrants or non-immigrants, I think the fact that the legal discussion we're having is focused on this area of, statements that the president made on the campaign trail, in a sense that is the argument here that we're talking about, to me underscores how capacious the statutory language is. And I think the other indicator is that, as Andre said, when he's talking about, and as Brantley said, focusing on the argument of there being insufficient, an insufficient finding, an insufficient showing of the national interest here. I think that's, given the capaciousness of the statute and Youngstown and the executive is acting at his apex here. I think it's a very tough argument from a legal's perspective to be made. And I think the fact that these are the arguments being advanced, I think speaks to how great a delegation of authority to the executive the statute makes. One can certainly have policy arguments about whether or not it's wise for Congress to do that. We can certainly have policy arguments about whether Congress should go back and put restrictions on that authority. But as the law stands now, that law is quite capacious. And I think, again, if the arguments do go forward, I think it'll be very interesting to see sort of which arguments the Supreme Court picks up on and how we see them dealing with the breadth of the delegation of power that's occurred in the statute.
Yeah, and I would just say just to put this in practical perspectives and, like to see where we can try to find some common ground. I think one issue that folks take with DAPA or with DACA is that it seems like it is a program, right? There is a manual, there's guidance for it. It's somewhat formalized. People, get this label attached to it. But it's also helpful to just step back and, from a practical perspective, think about it. There are 11 million or so undocumented individuals. Out of that, I think somewhere around 2 million would qualify for DACA. So there's a variety of measures. You came into the country before a certain age. Usually you were a child. You had to have been a minor. You were brought in. You've resided here the entire time. And in order to apply for DACA, you have to be screened for criminal history. And DACA does not apply to anyone who has in any way any serious criminal history. So if you think about an executive who's dealing with the issue of how to execute the congressional mandate of removal, how to say, okay, how am I going to deal with this issue? And you have a subset of individuals who you can say, well, let's take a look, let's put a lens on these individuals. Here are the individuals who are likely going to be the lowest priority. And so what can we do not only to identify who those people are, for them to come forward, and to know that, this subset is sort of the least, they're not a public safety issue, they're employed or they're going to school. These are individuals who are contributing to the society. So how do we place them into one category and go the other way? So if you think about it that way, and I think obviously there's a lot of wrapped up in how you place it that way, which can cause legal issues, and which are the things that were litigated here in the Fifth Circuit and will continue to be litigated. But I think if you just think about it that way, I think we would argue that is squarely within the executive authority to determine who to target and who not to for removal. And like I said, the DACA classification can at any time and does get revoked on an individual case-by-case basis. Some of which we've challenged, others we obviously haven't, but it is not in any way a grant of lawful status.
Just one very brief point on DACA and DACA having the caveat that you're not necessarily not removable as a DACA holder. We saw the information from Chairman Grassley recently that 1,000 DACA permit holders ultimately won citizenship as a result of their DACA permits. And so I think as a DACA holder, you have a fairly high degree of confidence that you won't be removed as long as you don't commit a crime during that period. So I know we can attach labels to it, but I think the information from Senator Grassley clarified what we all knew might happen, which is this could ultimately be a pathway to citizenship. And at a minimum, it's not a pathway for removal for someone who has a permit and doesn't commit a crime.
All right. We're ready to take some questions, and I think I see a microphone emerging over in this aisle. Let me just ask, if you have a question, go ahead and step up to this microphone and ask your question. I hope some people have thought of some good ones. We ask that these not be speeches, but rather questions for any of our panelists, or hopefully for all of them. All right, sir.
Good morning. Thank you. Thank you all.
Tell us who you are.
I'm Don Walker from Austin.
Okay.
Most of the issues you address with respect to seems to be executive overreach, and I appreciated the discussion on that. It occurs to me, and I think especially when Mr. Starr spoke about Congress ceding its authority with some of these laws, is it time to maybe try to breathe some more life back into the non-delegation doctrine?
All the debate is centered around agency deference since we had Justice Gorsuch's confirmation hearing. And I think perhaps the more fascinating topic is not deference, but delegation, the intentional grant of congressional authority to agencies, which has resulted in the administrative state being the size and having the power that it has. And under the Supreme Court's case, American Trucking, as long as they give some sort of intelligible principle in that law that delegates, and that's sufficient, which is such a low hurdle you could not even trip over it, right? You walk and you're over it. And so it really is interesting to see if after the court tackles perhaps agency deference first, if they will move to a more robust non-delegation principle.
Right. It looks like there's some potential for movement in Chevron an hour at least, which I guess is what you're talking about. Yeah.
Thank you.
Okay.
My name is Joshua Mize. I'm a private litigator in D.C. One thing that wasn't discussed was the fact that DACA doesn't just prevent someone from being removed; it allows them to work. And I guess my question to Mr. Segura would be, I agree with you about the president's prosecutorial discretion and the fact that if he's going to implement prosecutorial discretion, it has to be through a program. He can't be sitting there with individual prosecutors. They're doing his work. If he's going to instruct them, he's got to do it through some type of manual. But the removal is not the only part of it. It's the work status. So do you agree that that's the weakest part of your argument as to DACA being constitutional? And secondly, if President Trump's statements can be held against him on the travel ban, can those litigating against DACA cite President Obama's numerous statements that it was unconstitutional, and should courts consider those?
All right, so trying to figure out if I have to answer the second question. On the first question, I think that is a question most people have when they say, okay, so you're giving people who are undocumented some sort of ability to stay. What does that mean? What benefits are they going to get? So deferred action carries with it with presidential administrations going back, I guess, 40 years or so, the ability to get employment authorization. So that has always come attached to it by congressional statute, I think, to give employment authority authorization for individuals who receive deferred action, because I think the practical situations that, well, if you're allowed to stay here, you need to be allowed to work, to live, and to contribute to society, they pay taxes, et cetera. So all of those things come into play immediately on deferred action. On President Obama's statements, I haven't gone back to personally review them. I think whenever I'm reading sort of amicus briefs on the other side, they're always front and center. And I think, you know, personally, when I would look at them, I think the president would have preferred Congress to act during his administration on these issues. And I think he was saying, please act. Let's get something more formal. Let's get something more concrete. Let's get a pathway to citizenship for these kids, some of which no longer are kids, but who were brought here as kids. That's what I prefer, is what I think he was referring to, like something more concrete than just you get a 2-year reprieve, can reapply, you have to meet all these conditions, but you know, you could still lose it if you mess up and all of those things. I think he was saying, I want something better and more, you know, the law. And when that didn't happen, I think he said, okay, well, what's in my power? What can I do? And this is how I'm going to sort of figure out the situation for this subset of individuals. But yeah, I would have to look back and say,
aside from the
right.
merits of those statements, do you agree courts can wrestle with them and consider them and try to come to a decision about what he meant, like they did with Trump statements?
Yeah, I mean, I think I would have, yeah, I don't see why there would be any difference. I'm going to put a litigation caveat unless I go back and decide it's different.
Anyone else with a question? So, okay, Aaron?
You touched on the general rule that we don't psychoanalyze the lawmaker or the executive order issuer, but one exception to that rule seems to be the Establishment Clause. And could you all just discuss the Establishment Clause angle on the travel ban? Is that a real argument? I know the Fourth Circuit agreed with it, but is that going to have any legs in the Supreme Court? Could we just unpack that a little bit?
Brantley, do you want to?
Well, I think it's a novel concept to apply the Establishment Clause there, which is why I think, Aaron, in my mind, there's a preliminary question of does the Constitution extend to non-citizens who are seeking entry, right? And if you don't answer that first question the right way, the Establishment Clause has no place. Now, I don't believe that argument to be viable because I never get past that threshold inquiry, but the court might because it was hinting at this bona fide connection, and so it was extending the Constitution farther than I would have thought was permissible. And so we'll have to wait and see if the court actually takes up the case, if there is an intervening executive order, but to me, it's a bridge too far.
Well, I'll just add something as someone who is privileged to litigate Establishment Clause cases and defending governments when they're sued. It's sort of the I would say it is the usual case where we're always met in defense of in faced with an Establishment Clause challenge with some statement maybe that a board member has made out, not in a board meeting, to a press, at a speech, something like that. And I think our response to that, which usually is accepted, is that the government action that's relevant in an Establishment Clause challenge is the government's action, and the board acts. Say, take a board as an example, a board of county commissioners. The board acts as a board. It doesn't act, through individuals. So I think consistent with that view in the Establishment Clause context would be that where you have statements that the only statements that would be relevant is the government acting, the executive acting as the executive, the commission acting as the commission. So that's just another gloss on how such statements typically play out in pure Establishment Clause challenges.
Right, and I mean, obviously I agree that violates the Establishment Clause and that it should be, the court should take that up and could decide on that, obviously. But, I think just looking back at our immigration history, I think we should, recognize that religious discrimination in immigration was a concern. Like, we do not want a country where preferences on religion are used as a basis for entry into this country, whether as visas, whether as refugees, whether as visa holders, whether as refugees or otherwise. So that is a principle of our country. So then how do you weigh that in a case like the Muslim ban? And so there are some pretty heavy campaign statements and tweets. There are some doubling down on those statements afterwards. And in the first, in ban 1.0, there was a specific reference to a preference for Christian religious minorities in these countries. So, I think that it can be weighed. There's, a test that the court can apply. Obviously, there are a variety of ways in which the court could just say, we're going to go the route of the Ninth Circuit and just rely on 1182F and the anti-discrimination provision in 1152 and not address it. But
So let me throw out a question. This is kind of a pop quiz, I guess, for the panel because we hadn't discussed it specifically, but there have been various mentions of what Andre referred to lawful permanent status, where people can stay forever, and also reference to pathway to citizenship. In some ways, and this is more of a policy question maybe than a legal one, but maybe in terms of the policy debate in Washington, at least one elephant in the room is the question not only of whether people are or are not going to be deported, but whether they remain and have a legitimate and reasonable pathway to citizenship. And another element of that in the public debate is the suggestion that there are people who have been working on becoming citizens for a long time and have done so completely legally and have always been in the country legally. So the question is, explain to us how that works. Any of you help us out on that issue of becoming citizens and how that fits in administratively or otherwise or legally to the question of what you do with those who have been in the country but not lawfully and who wish to become citizens.
right, so I first off will give the disclaimer that I'm not an immigration law attorney. I don't practice immigration in immigration courts. But I think, there is the notion that we should recognize that some people, there is a tension. Some people do come in lawfully, stay, and then I think the sort of rhetorical response is, well, why can't everyone do it like that? Why can't everyone, wait in line? And I think there, the line for some, there is no line to even stand in. There's no practical line. For a Mexican immigrant who wants to come here to work, there's just no line for him to get in and say, I want to come live in Houston and start a construction job. There's no way that that's going to practically happen. And so there's not a way for everyone to come in the line. Some people have more privilege, more status, oftentimes based on their employment or education, as certain more immigrants who want to enter the country who have qualifications. So I think there are a variety of ways to get in, but I think that get in line and wait is not a reality for most people.
I'll respond a little bit. I remember back in my time in the White House, I think someone, don't remember who it was, had been out making a representation that under whatever version of immigration reform was currently at the time, that individuals who would benefit under that law that had been proposed, by the time they became citizens, would have gone through a longer, very categorical statement, would have gone through a process longer than anyone ever. And I sort of had the unfortunate job of calling the communications shop and saying, well, I hate to break this to you, but if you actually look at current lines and the countries, you have people, I think the Philippines, I think it might have been the Philippines, that people in the Philippines, I think it was currently a 14, maybe 15, maybe even in the decades wait. And I do think there is an issue. Remember back in law school, I remember at Chicago, if anybody ever tried to make an argument based on fairness, you just knew the professor was going to come after you. Because fairness, right, there's so many valences to fairness. And I do take Andre's point, but I also take the point that we do have a system where you have people who've taken our country at its word, and they're back in their home countries. They're going through a process. I don't think there'd be much disagreement among anyone, either in this room or Congress, that our current immigration system is in great need of more rationality and more repair. I think the debate we have is how our constitutional system permits that problem to be addressed. And I do think it is important to consider as part of this debate as a policy matter, to weigh the interests, not just to those for whom, as Andre says, essentially there is no line, because that's the way Congress has set it up, but also those who have been waiting in line for decades in their home countries, and how we craft reforms as a policy matter that are fair and that account for those interests as well.
Just like to quickly point out that if Congress were to give lawful permanent status to Dreamers without anything more in an immigration bill, then that would seem to be perhaps an incomplete policy solution, because then you're incentivizing those who have been waiting in line for the lawful ability to immigrate to the United States. You're incentivizing them to use the unlawful methods. And so I think that perhaps is why the president has been negotiating, trying to talk about DREAM Act plus border security. We'll see where those negotiations go. Congressional negotiations are not always fruitful, but I think that is why the debate is gravitating towards a two-sided coin.
Question?
Mr. Segura, one thing you said that jumped out at me was that, you said you think the Establishment Clause does apply to prohibit any discrimination in immigration based on religion, even though people who have no connection to the United States previously, was my understanding, and just in our general policies, we can't have any discrimination. And I think historically there has been a preference for how we chose our immigrants to how they were going to affect our country. So are you saying that would apply just strictly on the basis of religion? Or the formalistic, are you a member of a particular religion? Or would it be different if, say, Congress passed a law or the executive act to pursue that statute saying, okay, if you have a particular country where a credible poll or a credible, we believe that, say, 80% of the population thinks homosexuality should be punished by death or other criminal punishments, or that a huge percentage of the population thinks women should not have equal rights and should be property. Are you saying we couldn't, as a matter of controlling our country and who comes into it, say, okay, if 80% of the people think homosexuality should be illegal, we can roughly estimate that 80% of the immigrants will think that homosexuality should be illegal or punishable by violence, and we don't want those people here, so we're going to restrict those people, that people coming from that country. Are you saying that there's no ability at all to try to control and influence who comes into the country and what they believe and how they're going to vote once they get here?
Right. So on the first question about connection to the United States, which I think is, why are we, some of these individuals who are seeking entry are abroad, right? But if we, as a country, say had a policy that, the president issues an executive order that says we have, we will do this program, but, any Muslim abroad will not be allowed to do whatever. And I think just having that as a part of government policy is a problem for Establishment Clause. That causes harm to people of that faith who are here. The other way to look at it is that people who are coming in on visas have a often connection to people who are here. So when they're denied a visa and they're, if you accept that there is a preference or discrimination on the basis of that person's religion, then the person here in the country is harmed. So there's ways to think about it more so than just, okay, that person's abroad. I think on the question about who we allow to enter, I think that's exactly what 1182F is intending to do. Those decisions can be made on an individual basis, but if it is a categorical basis that is fundamentally based on religion for people when there's no individual determination that that person's entry to the country would be detrimental to the national interest. So sure, there may be someone in some country, just a bad person, and think, it's just, and the president and his attorney general can decide that person is going to be detrimental to the national security interests of this country under 1182F. But what the president can't do is use that categorically for millions of people located in another country when it's based fundamentally on religious grounds.
Anybody would follow up on that? Okay, question?
I have a follow-up, Mr. Segura, to that. The statute 1182F says class, and you keep talking about it, individualized determination is necessary. How do you get around the explicit language in the statute?
Right, so when it has been used for specific classes of people who have done specific things. So if there is a national security interest because there is a group of people who have engaged in a specific thing in another country, then that's different. So I think that what I would say is the class that's being argued is much more specific than people who are just broadly categorized under that for one reason.
So help us out a little bit, members of the panel, on one of the things that hasn't been mentioned here is that there is as I understand it, a history of immigration quotas that some might consider invidious in some ways and might favor certain countries or areas of the world or certain ethnic groups. Help us out on what the history of that is and whether, if you know, any of those quotas have ever been challenged. They're fairly strict, as I understand it, and fairly unbalanced in terms of various areas of the world.
Yes, and when you look, it really is we use the term a lot, a patchwork of quotas. And I remember a couple of times as someone involved in immigration policy in the White House, when I would ask, well, what's the history of this particular quota, which would seem odd, 9 times out of 10 I would get some explanation about Congressman so-and-so and had an interest. I mean, it's really really something, which is why I think if there's an area that there should be broad agreement on, it's that there's a lot in our immigration system that needs to be fixed. But by and large, to your point, Judge, in terms of legal challenges to that, go back to INS versus Shada. I mean, Congress's authority to establish a uniform rule of naturalization is beyond question. So I think from a legal perspective, in terms of the courts, when Congress is drawing lines and making distinctions and establishing rules and categories, if the president is at his apex in terms of 1182F, I think Congress is really acting in its plenary authority in setting these rules. And I'm sure someone in here, I hate to make a statement like this, will come up afterwards and prove me wrong, but I'm not aware of a legal challenge that has succeeded on the basis that is somehow beyond Congress's authority, or that there's another provision of the Constitution that interferes. And I do want to say one point to Andre. I mean, Andre's talked about the two statutes, sort of 1182F, and then he's talked about the statutory in terms of the non-discrimination principle. I do think it's important to point out that 1182F is talking about entry. It's referring to entry. And the other statute is really referring to visas. And I think one of the legal issues is going to be whether those two concepts are truly synonymous. such that there's a statutory constraint, or whether, as I think the administration would argue, that provision has no play with 1182F. And so if there's going to be a restriction on 1182F, it is going to have to come for the Constitution. It can't come from that other statute. So I just would throw that in the mix.
Gene Meyer, I think you look like you've had a question ready for a few minutes.
I do. I'm not quite sure exactly how to ask it, but if you have a group that is, or a country where you have a high percentage of people who clearly have a pretty negative view of the U.S., obviously that doesn't say anything about any individual who's trying to emigrate. On the other hand, if you have a situation where you want obviously immigrants who are supportive of your country and believe in it, what is the appropriate, sorry about that, what is the appropriate way to, and this is really for the whole panel, what is the appropriate way to balance that? First, even before you get to the legal question, just as a policy matter, how do you go about doing that? Because, taking, and it strikes me as very challenging. And I also think if you say, well, look, it depends on what the view of the country is, then you've got a lot of people arguing, well, we think the view of the country is X, and a lot of people disagree with that. So how do you go about that?
So, yeah, I think that's the question of what's bona fide and what's facially legitimate. And I'm not going to give you a satisfying answer, but I think what I will say, and that probably what I wish, I think people who would agree with President Trump's ban would have wanted, and would have maybe made it easier, is if he had actually set forth justifications and actual reasons for the initial Muslim ban. It was, done very quickly. There weren't actual specific factual reasons. And, one thing that people say, well, Obama identified these countries as also, for a particular focus. But what the Obama administration said for those countries, individuals can no longer qualify for the visa waiver program. So that was a way that they could, do it easier. They're no longer able to do that, so they're subject to additional review. So I would answer it by saying that what I think all of us would have wanted to see as for the justifications, actual justifications were not present in the first ban.
One thing I would add is that the travel ban executive order allowed for case-by-case exceptions, which I think gets to your point, because you might draw some broad categorical rule that applies to 80% of the citizens of a country, but there might be 20% who have the spirit that we want in America. And that case-by-case exception really allows you to ferret down and get into case-by-case, not just class-by-class types of individuals.
Question?
Yes. So I want to throw this open to the whole panel. It's more of a policy question. But regardless of what's going to happen with DACA, the travel ban, I mean, the fact is we have millions of people here, like Andre said, with only a certain amount that can be deported each year by the government. So the practical consequences of whatever happens, you have immigration court system that's, each judge has about 1,800 cases on their docket. And you have people who are in immigration proceedings who, if they're not detained, are being reset to 2021 and 2022, which has been a result of DACA, of the surge, of the kids being given a priority to have their immigration hearings. So what's going to be done policy-wise to address that when you have people who are going to be here 5-6 years, regardless of what's going to happen?
Yeah, I mean, I think you've identified another huge problem to the system, is that it's overloaded, the IJ system's overloaded. I think there's a push to hire more immigration judges, but yeah, I mean, I think that is a real practical hurdle, which I think would go to my point about sort of presidents determining here are our priorities, and even if it's done in a more formal way through guidance, that's why I think these things need to happen. I don't, as you would suspect, don't agree that DACA has caused a surge or is a reason for it. I suspect there are differing agreements here, but yeah, that's what I would say to your point. But yeah, I think you're right about the immigration system being overloaded and backlogged and being a problem.
That was past our last question, and the question I received is, do we still see a case or controversy going forward given the changes to the bans?
I think those who are preparing their arguments would probably say, of course. Of course there's a case or controversy. Now, if the day after we have argument, you want to,
Yeah.
depending on how argument goes, disagree with me.
So our ACLU line is that the devil's in the details, and we have to get down and see what's actually in the new one.
All right, let's give this panel a big round.